Good day, this is Liesl Pretorius, Legal Advisor for Freedom of Religion South Africa, or 4SA for short. Welcome to our weekly discussion on issues affecting faith and freedom. Today, I'm joined by my colleague Daniela Ellerbeck, fellow legal advisor with 4SA, to discuss the Prevention of Hate Crimes and Combating of Hate Speech Bill, or simply known as the Hate Speech Bill. Now, on the 14th of March 2023, the National Assembly, which is Parliament's first house, passed an amended version of the bill and then transferred it to the National Council of Provinces, Parliament's second house, for concurrence. The NCOP is set to start considering the bill this week. But before we look at the parliamentary process, where it stands and what is expected to happen in the next few weeks, let's start by recapping what this bill is about. Daniela, can you quickly take us through the bill?
So the bill proposes criminalizing expressions that the bill defines as hate speech. So obviously, if you're talking about criminalizing something, it's very important what the law says that thing is. And the bill, in simple language, defines hate speech as any expression, so words or conduct or a display of something that is, one, harmful or incites harm, two, promotes or propagates hatred against, three, a group of people specifically listed in the bill. Now, if you're found guilty of this crime of hate speech, the bill proposes that you should be sent to jail for up to a maximum of 8 years. So that we're talking a very, very heavy prison sentence for words.
Yes, that is quite a heavy prison sentence, Daniela. And 4SA has several concerns with the bill. Could you quickly run us through these concerns?
Well, firstly, the crime of hate speech is overbroad. So a primary concern, like we said, if a law makes something a criminal act, it's very important how the law defines that thing. And a primary concern is that the current definition of hate speech in the bill is very, very wide. So as we've said, in simple terms, the bill says that the crime of hate speech should be defined as any expression that is harmful or incites harm, promotes and propagates hatred against a group of people specifically listed in the bill. So we see that a lot depends on how the bill defines harm and a lot of how the bill defines hatred, as well as which groups of people are specifically listed in the bill that one shouldn't be able to say anything against. And this is where the pawpaw hits the fan, Liesl, because let's simply look at the first element, harm. The bill's current definition of harm includes substantial emotional, psychological, physical, social, or economic detriment that objectively undermines the human dignity of the individual or group that the speech is targeted against. So let's just think about that, all the different types of harm that there are. Is we have vague things such as social harm being included in there. Now, social harm is new to South African criminal law from this perspective. And I remember when we were sitting in the parliamentary meeting where the Department of Justice was saying to Parliament social harm should be included as a type of harm of, that hate speech can take. And Parliament asked the department, okay, well, what is social harm? And the department had to get back to Parliament on it. And finally, when they did, and this is the definition that's in the current version of the bill being considered by, as you've said, the second house of Parliament, they say that social harm should be anything that undermines the social cohesion of peoples in South Africa. So this definition, one can see when you're dealing with a crime, is still very unclear. It's still very ambiguous. And it therefore remains a very, very nebulous concept. Now, other types of harm that we mentioned are also included, for example, are emotional harm, so hurt feelings. Now, emotional harm is not psychological harm, which psychological harm, for example, would be able to be objectively determined by a medical practitioner who evaluates you and gives a diagnosis that, Daniela's words to Liesl caused Liesl such psychological harm that she now suffers from this psychological condition. Emotional harm can't be determined that way. Emotional harm is feelings. So we are talking about finding someone guilty of a crime and sending them to jail for up to 8 years for words that theoretically could have substantially hurt their feelings. Now, let's also just talk about the degree of harm that's being proposed. It is not gross, which someone might expect. given the heavy jail sentence being proposed. So it's not that gross emotional or gross psychological harm is required. It's merely substantial. Now, 8 years in prison is something, for something that you say, it's a very, very harsh sentence. I'm willing to bet that many murderers don't even spend 8 years in jail. Now, this is an especially harsh sentence because the bill does not require the state to prove that your words caused any actual harm in the real world reality. Thus, the entire question becomes a theoretical one. Could Daniela's words possibly have resulted in substantial emotional harm, substantially hurt feelings to Liesl? To emphasize the point, what you said could be judged to be criminally harmful, irrespective of whether anyone in reality actually suffered any emotional harm. So what we see here is iffy, hard to define, and almost impossible to prove, hence why no direct causal link is required. For example, how do you prove social cohesion is being undermined? Concepts of harm being included in a criminal law that can send people to jail for words for many, many years.
Yes, Daniela, like as you explained now, it's very concerning that you have this concept of harm that is so wide, that contains concepts that are hard to define. As an attorney, it begs the question, how will the public know whether they're committing a crime or not? Somebody who wants to avoid committing a crime, they're left with questions. And what I'm doing, is it wrong? Is it not wrong? I'm not even actually causing actual harm. It's potential harm. It raises a lot of problematic issues. And just moving on to the next big concern, if I understand this bill correctly, it wants to make a crime. Basically, you can go to jail for up to 8 years, which is very harsh. As you say, some murderers don't even go to jail for up to 8 years because somebody says something that is harmful or incites harm. And nobody needs to prove, as we said, that harm has actually occurred in any way, shape, or form in reality. And it promotes or propagates hatred because this is the crime of hate speech. And this hatred is promoted, propagated against a group of people specifically listed in the bill. So the first element is harm. But the second element is hatred, because this is the crime of hate speech. That's the quintessential central element. So one would think that's very important concept to define. So what is hatred according to the bill?
Liesl, exactly. You hit the nail on the head. One would think that the hate speech bill would tell you what hatred is, especially because it's going to be sending you to jail for up to 8 years for committing the crime of hate speech. And like you said, Joe Public needs to know what is hate speech so that he can decide not to do it. And he doesn't make himself guilty of it. But because we sit with these wide, vague definitions, we've already discussed harm, and now we're getting onto hatred. The law is very unclear, and what's going to happen is that people are going to self-censor. They will rather not say something than possibly say something that can land them up being prosecuted for hate speech, and if they're found guilty of hate speech and convicted, then sent to jail. Now, as you said, hatred, one would think that hatred would be very narrowly defined, very tight definition, very high threshold that needs to be met by the state, because when we don't want to send people to jail for offensive speech. And we're talking about the hate speech bill. Surely hatred has a definition. No. Again, the bill fails to define what hatred is. So we do not know what the second element, to promote and propagate hatred, in terms of the bill actually means. Possibly because hatred is itself a very notoriously difficult concept to define. Nevertheless, Parliament is proposing making it a crime to say or display or share anything that could potentially result in substantially hurt feelings that promotes and propagates some undefined hatred against a group of people specifically listed in the bill. And this brings us to another problematic area of the bill, which is the group of people that are listed in it. And the latest version of the bill still goes much wider than the Constitution. And some of these grounds are highly controversial and are also undefined in the bill. So we're sitting with very fast changing, I would say, almost liquid definitions, for lack of a better description in the bill, that are morphing very fast, even in contemporary pop culture, such as, for example, gender identity and gender expression, which don't mean the same thing that they did 10 years ago. So we should nail these things down when we're talking about a criminal law so that everyone knows when they're committing a crime. We don't want a situation where we pen something down in a criminal law. 10 years from now, it means something completely different to what it does now. And we unintentionally send people to jail.
You mentioned that the bill goes wider than the Constitution, Daniela, and that is concerning because we're talking about the limitation of freedom of expression, which is a fundamental right, and freedom of expression is closely linked to freedom of religion. That's why 4SA is concerned about this bill. And so what the danger is that this bill is limiting constitutionally protected speech. And we don't want constitutionally protected speech limited more than is absolutely necessary and justified.
Yeah, I just want to jump in there and say we're talking about this bill is not even limiting constitutionally protected speech. It's criminalizing it.
It's criminalizing it. And nobody supports real incidents of hate speech. That should be condemned. But the definition of hate speech should be constitutionally aligned. And also South Africa has certain international obligations. And some of these documents will say, hate speech must be punishable by law. But it does not require it to be punishable by criminal law. In fact, the United Nations position is more speech, not less, is the key means of addressing hate speech, and that when speech is criminalized, so you have your civil remedies that, like we already have in terms of HUDA, the Equality Act. If speech is criminalized, it must be a last resort when it is absolutely necessary. So that is something that needs to be kept in mind. We don't want to undermine fundamental right to freedom of expression because it's so central to democracy. So, Daniela, we've talked about, that 8-year jail sentence, it's still around, but is there some light at the end of the tunnel? Is there any exemption that clauses in the bill that helps protect constitutionally protected speech so that people will not end up going to jail for saying something that should be protected speech?
So, Liesl, I just want to touch on something before we get to the exemption clauses that you mentioned, which is that the UN's official position is more speech, not less speech, is the solution to hate speech. And the reason in part that is the official position is because the moment you criminalize hate speech, for example, you drive that view underground, you don't get rid of it, and it becomes more nefarious. It becomes like cancer. Whereas the moment, for example, Daniela says something and people find it offensive, but it's public, I can, be persuaded, by example, yourself, that I need to have a different view or that I'm wrong. I can incur public censure for what I've said, and people can say they disagree with me, and it can start a public debate. Now, the moment you say to people, you could possibly, find yourself guilty here of hate speech because there's going to be hurt feelings, you might be undermining the social cohesion, who never knows what that is. We don't know what hatred is, so, that's going to drive that view underground, and people aren't going to be able to debate it out. And South Africa is really, really, really going to lose something very crucial and essential for a democratic society, which is that we need to be able to talk about things in the public realm to arrive at the truth and decide what we as a nation want to do about something. So turning to your question on exemption clauses, the bill does have exemption clauses. And I want to say that this is already an improvement because the very first version of the bill did not have exemption clauses. So this is already an indication of the fact that the public participating in rulemaking and sending in comments has an impact. Now, the problem is that the exemption clauses are on very narrow grounds. So they are, for example, artists, academics, journalists, and religious people. Now, they are also problematically drafted because they find themselves to be drafted in quite a circular fashion, which I'll explain now, which means that they end up being self-defeating. So to give you a summary and example, they essentially say something along the lines of a person in good faith, who in good faith, for example, shares a religious belief, or an academic who in good faith writes a journal article, or an artist who creates something in good faith, or a journalist who reports on something in good faith, is not guilty of the crime of hate speech unless what he or she says advocates hatred, which our constitutional court has already said can be understood to mean the same thing as promoting or propagating hatred, that constitutes incitement to cause harm against a group of people specifically listed in the bill. Now, is this sounding familiar? And that's because they're essentially the same three elements we just spoke about being the elements of hate speech, which is harmful to incite harm, promote and propagate hatred against a group of people specifically listed in the bill. That's a crime of hate speech. The exemption says you're not guilty of the crime of hate speech unless what you say advocates hatred, which is the same as promote and propagate hatred. And we know that hatred is undefined. That constitutes incitement to cause harm, and harm includes wide concepts, vague concepts, nebulous concepts such as social harm and emotional harm against a group of people specifically listed in the bill. So we see they basically match up, and that the exemptions themselves are quite circular and actually fail to protect, because we have these wide definitions for harm and this no definition for hatred. So what we see here is that essentially all the exemption clauses managed to achieve at the moment as a result of drafting is that one's not guilty of hate speech unless what you said is hate speech.
That's not much of an exemption at all. It's something I noticed. Section 16 of the Constitution, specifically Section 16(1), lists certain is constitutionally protected speech, journalistic expressions and artistic expressions, etc. It includes the protection, the exchange of ideas, for example, information ideas. I did not even see that under the exemption clauses. So my question is, so you're not an artist, you're not an academic, you're not a journalist, you're not a religious person, you're just like a Joe Public atheist, secular atheist. And you also have ideas, you also have worldviews, which the Constitution should, attach the same weight to as other people's views, because we all have human dignity and we're all equal before the law. And now you express your views. Are you protected? Where's your exemption clause?
So exactly. So, I mean, perhaps let's just, I want to touch on two sections. Section 16(1), which you've just mentioned, which is the freedom of expression clause in our Constitution, where after the apartheid state that censored people and sent them to jail for speech, we finally in our democracy got a constitution that protects freedom of expression in Section 16. Ironically, we're now talking about a democracy sending people to jail for speech. Now, Section 16(1) says that everyone has the right to freedom of expression. So expression is wider than just words. As we've said, it's conduct, displays. I mean, if I want to make a statute and put that outside our office, that is also expression. That's a form of expression. So it's wider than just speech. And the Constitution says that everyone's right to freedom of expression specifically includes freedom of the press and other media, so one can see why there's an exemption clause for journalists. Freedom of artistic creativity, so one can see why there's an exemption clause for artists. Academic freedom and freedom of scientific research, so again, we can see why there's an exemption clause for academics, as well as the freedom to receive or impart information and ideas. And the closest we can come there to an exemption clause is the religious exemption clause, because we know that Section 15 covers and specifically protects freedom of religion, which includes the freedom of conscience, religion, thought, belief, and opinion. Now, I mean, I would totally say that this bill also needs to include an exemption clause for the freedom to receive and impart information and ideas. And on top of that, the exemption clauses that do exist for the protected rights. So we know that artists have their right to freedom of expression specifically protected expressly in the Constitution. Same for academics, same for the media. And then we know that freedom of religion is wide and includes the freedom of thought, belief, opinion, conscience, and religion. So we see there also that it's specifically protected. So we can understand why these are specifically included as exclusions, but we need to see these exclusions tightened up, and we need to see the freedom to receive and impart information and ideas also specifically included.
Absolutely, I agree, Daniela. I think our constitutional court has said that in South Africa, we should strive for unity in diversity, not unity in conformity, and we need to be able to impart and receive information and ideas in public discourse, a respectful discourse, of course, because in South Africa there are people holding various views and positions, and if we do it respectfully, we can, treat everybody in a way that affirms their inherent human dignity and their equality before the law.
Exactly. And I mean, I don't think anyone here, I know for myself and for you, no one here is a free speech absolutist where you should be able to say whatever you want to say and never face any consequences. But again, as we've said, the problem with this bill is that the elements of the bill are far too, the standard is far too low for a criminal law, and the elements are far too wide. So the fact that there's no direct causal link required, the fact that the heavy jail sentence of 8 years for expression, the fact that hatred is undefined, harm is overly broad, it's broader, harm is more broadly defined in the hate speech bill than it's defined in the civil law. The civil law, where you can be ordered to apologize and pay a fine, has a narrow definition of harm than the hate speech bill, which can send you to jail for up to 8 years. So all of this is very problematic because, I mean, the Constitution, on top of giving freedom of expression, also excludes certain forms of expression from protection, namely propaganda for war, incitement to imminent violence, and the advocacy of hatred based on race, gender, religion, and ethnicity, or ethnicity rather, that constitutes incitement to cause harm. So when we are looking at criminalizing hate speech, we need to make sure that we protect constitutionally protected speech, and therefore that we set a very high standard, a very high threshold, so that we don't create a very big, very wide net that catches lots of forms of expression in it and clamps down on public debate and free speech in a democracy that very much needs it, because you can measure a democracy's health. In one way of doing that is by looking at the amount of freedom of expression that there is in the public realm.
Absolutely, Daniela. And I think that to the extent that there are differences between the people of South Africa, if we can have more respectful public discourse, not less, not shutting people down, not people instilling this fear, what am I saying that's wrong, then we can actually bring people together. We can actually heal our nation, which would be fantastic. But moving along, so we've talked about all these issues with the bill in its current version, but where is this bill currently? We know it's at the NCOP, but what's happening next?
So perhaps to recap for listeners and viewers, Parliament has two houses and a bill, in other words, proposed law, needs to pass both houses. Then it goes to the president, and once he signs it, it becomes law. Now, where we are at the moment is that the first House of Parliament, the National Assembly, passed this version of the bill that we're talking about on the 14th of March, and then handed it over to the second House of Parliament, the National Council of Provinces, to consider. Now, 4SA has been in contact with the second House's relevant committee that will be dealing with the bill, namely the Select Committee on Security and Justice. And provisionally, it looks as if the bill will be opened up for public comment as soon as Friday this week. In other words, Friday, the 21st of April, 2023. And the committee aims to finalize the bill by the first week of June. So we see a very, very, very tight timeline. And I just want viewers to note that public comments will be open very, very soon. And 4SA will make an example submission, a template submission available for you to consider and change and amend and share as wide as you want, just to make it easier for you to make your voice heard on this very, very, very important process. Now, if the Select Committee adopts the bill, a plenary sitting of the NCOP will take place where they will vote on the bill or not. If the bill was passed, so it's gone through both houses of Parliament, President signs it into law. Hopefully, there'll be some time for that, but given that there seems to be a lot of haste to get this bill through before the 2024 election, it might be as early as August this year, everyone had to guess. Now, as always, 4SA will follow the bill's process and we'll keep you up to date on any new developments. But do keep an eye out on our website, www.frsa.org.za. We will definitely show and advertise there once the bill opens up for public comment and make the template submission available for you to download. The same can be said of our social media. You can follow us on Facebook at Freedom of Religion SA.
Thank you, Daniela. This has been a most insightful discussion on a very significant bill, perhaps even one of the most significant bills concerning our democracy in recent years. It's definitely not a time to be complacent, I would say, if you're serious about freedom of religion, freedom of expression, and indeed the health of our constitutional democracy. Thank you for joining us, viewers. Until next time.
Good day. This is Daniela Ellerbeck, the legal advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.